not listed today. That's the...
Pardon me? When you have given the date for listing?
Yes, my lord, it was supposed to appear today.
আজকে ছিল?
Yes, this is the matter. It was due to appear today. Monday, my lord, is the AGM. And
Which bench has passed this order?
your lordship,
Sitting with whom?
my lord, Justice.
Okay.
না না এই কার সাথে বসেছিল
ও আচ্ছা আচ্ছা।
দেখি কোন অর্ডারটা
আজকে লিস্ট করোনি কেন এটা? হ্যাঁ,
এই অর্ডারটা দেখো।
দেখি অর্ডারটা দাও। No, there is no order. We dispose of the
Lord,
we dispose of the application.
yes,
But you file an application.
I have filed an application.
We shall see to it. You file it, we shall see to it.
My lord, it is already filed, my lord, by Tuesday.
You file, you shall see to it, madam.
Today, my lord, Monday.
No, not today. Sorry,
No,
we'll take it up.
My lord, Monday is the AGM.
We'll see to it. We'll see to
My
it.
lord, may I be
We
permitted?
don't want to scuttle the process.
No, can
An honorable judge has been appointed. We will not.
the only thing, my lord, the very person against whom allegations were made in the
Very
plea,
well,
my
we
lord,
shall-
he is appointing that person only for everything.
Maybe that is for the discretion of the chairman.
Okay.
Yeah.
Don't find anything. Retired High Court judge has done it. Sorry, madam. We'll see to it. Yes.
Matter-
Yes. We shall consider. We cannot promise.
May I
Yes.
be permitted to make one upgradation request because this matter is...
No arbitration, please.
My lord, correction. For correction.
Give.
My lord, may I be permitted to mention this matter for assignment? But a peculiar situation has
For?
arose. For assignment.
Yes, you give it to the secretary. Yes.
41.
Yes.
My lord,
You write a letter to the. Don't give this. You write a letter, proper letter.
My
To
lord,
the
one thing only is that
you write a letter proper to the secretary. Yes.
order 41.
Give.
Lordships, may I be allowed to mention one matter, Your Lordship? This is under the Customs Act, Your Lordship. The goods have perishable.
Give.
With the leave of Honorable Justice Chaudhary, my lord, this is I'm mentioning a review matter which pertains to the RLST, my lord. It was listed on 12th
Yes,
September.
we shall try to reach it. We
My
don't
lord
know
was
when
sitting
we
with
will-
Justice Smita Das Day, my lord.
It's very difficult to sit with that when we try to reconstitute.
My lord, the crux of the issue is that if the examination is taken up in the month of November, my review petition will be infructuous. If
Let's see if we can try to find them.
For correction, my lord, can you?
My lord, may
I indicate the review number, my lord?
Correction টা আছে।
My lord, may I permit to mention one matter? Appellate prefer against the lower court order. Execution is pending at lower court. Now, my lord, lower court is giving the notice that the
No, order 41.
yes, lordship, first
Order
appeal. It is a
41.
first appeal.
Yes, you give the slip.
Earlier occasion monthly list is all running.
লিস্টে অ্যাপিয়ার করছে না কেন দেখে নাও। Have you given notice?
Yes, sir. The notice also there.
It will appear. Yes.
Lordships may kindly take it up.
On Tuesday, it will have understood. Hearing matter will not taking up the hearing matter.
Execution
For the-
is pending before this lower court.
Yes, you take out an application to sit with. Take out an application.
Also, other side serve the notice to also.
Have you taken out any application? Is there any stay?
Yes, stay.
Have you filed any application for
So,
stay?
lordship stays whatever result will be taken by the lower court, it will be abide by the
Yes.
result of the
Yes,
appeal.
So you are protected.
That's why lower court is saying that you have to prefer any stay order. This is not a stay order actually.
Let the trial court consider this, we shall sit with. Let the trial court constitute our order, we shall sit with. Yes. Yes.
Eight, daily list, serial number 1.
For the petition, appellate.
কোনটা? সেই নাও। Correction will not do in this bench. We'll do it in the when Monday. এগুলো সব Monday. Monday. Corrections on Monday because this bench is.
So item number 2, this bench is the correction, the necessary correction may be carried out, Lordship.
Which bench has passed the order? Myself.
This bench. Yes. This bench. Yes.
Hello.
Item 2.
Item
order
2 টা
correction
কোন
চাইছে।
benchটা দেখো না। Monday.
Item number 3 also.
Monday.
Grateful.
Yes.
Serial number 4.
I appear for the respondent.
For the appellant.
We'll take it up on Monday because this is an assignment. This bench will not.
Alright, could it be Tuesday, my lord, instead of Monday?
4 and 5 then on Tuesday.
Great.
Is it my lord's pleasure to list item number 5 on Tuesday?
Yes, Tuesday.
Serial number.
Very well.
Serial number 9.
Grateful, my lord.
Ma'am, I'm for the appellant in this matter, my lord. This is an application for restoration, my lord. My lord, August 25, 2025, my lord. I tried to serve copy of the application, my lord, upon the learned advocate appeared before your lordship. On behalf of the respondents, my lord, they refused, my lord. Kindly give me time, my lord. In the meantime, I'll serve the copy of the application upon all the respondents, my lord. Kindly fix it, my lord, 1 week after vacation. There are 11 respondents, my lord. August 21, 2025, my lord.
No, you have not removed the defense as yet.
My defense, I have taken steps, my lord. I have procured the papers, my lord.
On 4th August 2025.
My lord, the 2 weeks time was
in your
granted, my
presence,
lord.
no, in your presence, we have passed this order.
I know, no, my lord, dismissal.
On 4th August.
Yes, my lord. Thereafter, my lord, I have
given you time.
My lord, thereafter,
And
my lord, I have obtained the certified copy of the lower first degree, my lord, and
you
other
did not
papers,
appear.
my lord.
Now that it is dismissed, then you are coming.
My lord, kindly give me my lord, a chance, my lord. I'll cure the defects, my lord.
And it's an order of affirmation.
My lord, kindly.
Order of affirmation.
My lord,
You are delaying the process.
No, my lord, kindly.
What do you mean by no?
My lord, kindly.
You are not appearing. You are appearing as and when you feel it is necessary to appear.
No, my lord, kindly give me opportunity.
You will not remove the defects.
My lord, kindly give me opportunity, my lord.
If the pendency of this application will not operate as stay, we make it very clear. Take down.
affidavit of service, my lord. Some of the respondents, my lord, served. Some of them, not all, my lord. On last occasion, they appeared. Mr. Shankar Pal, I think, my lord, he appeared on the last occasion.
You were not present on the last occasion.
My lord, I was not present on that. There is Section 5 application and one application for stay of the further proceeding of the for the final decree.
And who is the section 5?
Section 5 is can
Please
2.
stop.
Some of the respondent, my lord, received and they appeared on the last occasion. I did not appear on that date. But 88 days delay, my lord, in preferring this appeal.
But what is the wrong with the judgment? You
My
come
lord,
to the finding. What is the wrong with the judgment?
wrong, my lord.
You come to the
My lord,
internal.
they are
You come to the internal page 13 of the judgment.
But kindly come to the. They are not the owner. We have challenged that they are the ownership of the plaintiffs, merit.
You have admitted the case of the defendants. The defendant number 11, Abdul, sold out 7.5 decimals of land to Musarat, who has been implemented as defendant number 14 to the suit. So you cannot have a claim over 7.5 decimals.
Malat, I am the defendant in the suit. I am the defendant in the suit. Malat, kindly come to my application for stay.
You are the defendant in the suit.
Yes, the defendant, respondent number 1, 2, 3.
Now you are the defendant in the
10
suit.
to 30.
So
10 to 30.
this was decided in your favor.
But
10 to
30 before the landed court below.
Yes, so you are challenging what?
I'm challenging the preliminary decree.
Allocation of share to the plaintiff or to the other defendants?
Malat, the allocation of share as well as Malat, their ownership.
You are defendant number?
10 to 30.
You did not contest.
Malat, I contested, Malat.
No.
Kindly see the order.
No.
Judgment, Malat. Yes.
You contest.
I contested, Malat. I'll kindly see.
So what is your defense to the claim?
10 to 13, Malat.
No, very well. What is the defense to your claim?
The defense is, Malat. Kindly see their plaint, page number 12 of my application. The stay application, Malat. Kindly see.
You have, if you have sold 7.5 decimals.
No, Malat. I purchased it in the year 1958, 30.
Your case is that the defendant, the plaintiff admitted defendants.
Yes.
The defendant number 11. You are defendant number 11?
No,
you have
10
sold,
to 30, all.
You are part of the part of that group.
Yes.
So
But
you have sold 7.5 decimals of land to Musarat. Who is Musarat? Who is Musarat?
Particular Musarraf is.
Who is Musarat? Tell us.
Musarraf was not made party. Was not made party by them. When I sold.
Musarraf Hussain Mullah.
Yes. They were not made party.
No, his party is defendant number 14.
Musarraf defendant number 14.
Defendant number 14.
I am for 10 to 13. I am 10 to 13. 10, 11, 12.
You admit this is your own case.
But it is my land. My land I sold 7.5. Out of the 30, because initially Prasanna Kumar Khan was the owner of 45 decimal of land. Out of 45.
You have admitted it. If you have admitted it.
Yes.
So what is wrong with the judge?
But I'm coming. I am just concerned about 30 decimal land. Out of 30, I sold 7.5. There is no dispute. But they have claimed out of 45, they have claimed 4 decimal of land. But kindly see their prayer once. In the plaint, they have prayed for preliminary decree of partition.
The first appellate court said,
yes,
plaintiffs purchased 4 decimal of land.
Yes.
From Prashanto Kumar
Khan.
And that deed is exhibited. The deed speak for itself, whatever you may say. So 9.1, the deed speak for itself.
Yes, I purchased in the year 1958.
Prashanto, no, you mean to say that before the plaintiff's purchase, you have a prior purchase deed?
Yes, 1950. 1950. Kindly see my written statement.
Was it by a registered deed?
The registered deed, my lord. Kindly see my written statement in page number 80 of my application.
What is your evidence? What document?
Evidence is, my lord,
what is your evidence to show that?
Yes.
Because based on that purchase deed,
Yes.
they have also mutilated their name in the records.
1 minute, my lord. My lord, I am just giving the reference, my lord, what I have. My lord, deed number 1021 of 1958.
See,
which was
your case was
yes,
that Prashanto sold 30 decimal of land out of 45
to us, to my predecessor.
to a registered deed
Yes,
of sale in 1958.
1958. Yes. And they purchased in 1985.
No, that is 30 decimal out of 45
Ha.
and delivered possession to him. During
Yes.
possession, Chamed Ali Khan died, leaving behind his 4 sons.
Hmm.
Has admitted that a aforesaid positive case of the defendants.
Yes.
So, if you have 30 decimal, what this says this, what the learned judge has said is that plaintiff jointly have got undivided 04 decimal of land in respect of the suit property. Because the other co-sharers of Prasanna could be there. Other share of Prasanna could be there.
Yes.
So what is wrong with that?
But kindly see-
That part is there, and so far as you are here, it's only a declaration of title to the plaintiffs in respect of 4 decimal of land.
But kindly see the plaint where they have admitted there is a mistake or error in the deed, which they admitted. The number which is mentioned, the dark number which is mentioned in their deed and in the schedule, it is separate. Kindly see their plaint, paragraph number 2 I have annexed in page number 14.
It is a registered deed of sale.
But I'm reading for my.
No, it's a registered deed of sale. No one has
Yes.
done a rectification.
Yes, yes, yes.
So whatever the deed
They have
says,
not rectified it.
whatever the deed says, that deed remains.
Yes, but court has interpreted. This number should be that. The court has interpreted in the page number, in page number 11.
Page
11 of the internal page, my lord. Kindly see the judgment, the impugned judgment. Page number 11 in my memo of appeal, my lord.
No, no.
On close scrutiny, the schedule of 3 deeds, it is found that plot number 1
Page 11
of the judgment, my lord. Internal page 11, the certified copy. It is found that though plot number 1090, my lord, it is in Bengali 1090 Bata 1555 has been written in, but in words it has not been written 1090 Bata 1555. In other words, the plot number as mentioned in the schedule appears that Bata plot. Court has itself interpreted, my lord, learned court below. But considering the description of the plot number in words, it cannot say that Bata plot number has been mentioned. From the schedule of the deeds, it is crystal clear that plot number 1090 is the RS plot number.
Absolutely correct.
But it is not
Absolutely
written in
correct.
the deed.
Doesn't matter. Description is there.
But it is interpreted like this. And they have mentioned in the plaint. It is an error. It is interpreted in their deed, my lord.
Description যখন আছে, the court has, if there's a mistake,
Number 1. Number 1 of their plaint, it is written, be it mentioned here, that due to the mistake of scribe in the deed of the plaintiff as well as the deed of the defendant number 126 in schedule such and such, plot number 1099/1555 was written. But in fact, plot number 1090 is a RS plot, where the plot number 10555 is a corresponding to error plot. In fact, there is no existence of the 10. They have admitted. There is no existence. Either in the RS or in error. Alright, some of the respondents served. That is why, my lord, my learned senior friend, Mr. Shankar Pal appealed.
এরা কেউ ফাইল করেছে? service.
Affidavit, sir, I've served.
Fine. Affidavit.
Today.
Plaintiff served.
Plaintiff, 1 to 3 is the plaintiff.
Served.
Yes. 1 to 3 is are the plaintiffs.
আমরা যেটা বলেছি না
Application, my lord.
For respondent number 1.
It's a appeal from
You are the you're for the land
Land
acquisition
acquisition
collection.
land acquisition, my lord, section 18, my lord, there, my lord, certain facts had not been considered. Admitted that the life of a tea estate, my lord, tea plantation is 60 years, but still it has gone as capitalization method instead of, my lord, yielding method, or loss of my yield.
There is no scope for any stay. You
I
file an
have,
appeal.
there is,
Paper book.
They have prayed for me, Lord, deposit of the decretal amount by us. That prayer I am opposing because, Lord, it is their appeal. So there's no scope for stay. So the respondent is not, Lord, to deposit the amount. They have to file execution for that. Kindly say prayer A and A, B and C.
You have not paid, you pay it. You pay, why execution? You are admitting that amount, whatever the amount is
admitted
admitted,
amount I have gone by.
But
there is no cross appeal.
cross appeal, I have just received the appeal. So Lord, the time for preferring cross appeal is, Lord, from 30 days from, Lord, getting the, Lord, notice of appeal. So time for cross appeal is,
You are not so far agreed by the order, correct?
so far they have not preferred, Lord, but I don't have any instruction that they are willing to pay this amount, Lord. So cross appeal, Lord, provision is
When
still
the
there.
order was passed.
In 2016, my lord. Data
So, Lord, period for cross appeal is, Lord, 30 days from the date of.
We know.
25th
know.
April 2016.
There's no difficulty on that.
So I can still prefer a cross appeal, Lord. If they, I'll confident that.
You have not preferred an appeal as yet. Independent.
has
No
not
one has prevented you from filing an independent appeal.
That has not been preferred.
So don't be riding on his shoulder. So it's an order of 2016.
Mal.
So why you when you have preferred the appeal?
Within time, my lord, within
time.
Within time.
So for this, your appeal will be time barred.
No.
Your appeal,
Appeal
will not allow you that.
Appeal will be time.
So you deposit the amount. Take down.
No, Lord, kindly consider this.
No,
They have not filed execution.
Absolutely
They
not.
have to go to
For the
petitioner.
You are for the appellant.
I'm for the appellant petitioner.
You are
There
for?
are two,
Madam, I have filed an application
there
for
are two applications.
addition of parties, my
One
lord.
is CAN 4 and
Because
CAN 6 is my application, my lord, and CAN 5 is my learned senior friend's application.
Suit for?
Suit for declaration,
That the,
injunction, and my lord, recovery of possession.
my lord, CAN 4 and CAN 6 is my application, my lord, and CAN 5 is my learned senior friend's application, my lord. CAN 4 is an application for appropriate order, my lord. That
But the appeal is ready, paper books have been filed.
appeal is ready. It's for substitution, my lord. CAN 6 is
It's
for
for substitution.
substitution, and CAN 4 is also in the nature of substitution,
Just a
paying
minute.
for deletion.
CAN 5 is for what? Addition of party.
No, not
My lord,
CAN
can
4.
5 is addition of party, that is my application. Because my lord, I have
to file an
purchased the property from the defendants, my lord, so I have filed in the application for,
Accumulation of interest.
yes.
My lord,
So first we allow this
CAN 4.
can 5 or
CAN 4, my lord. First
Uh,
CAN 4.
can 4.
CAN 4 is an application where I have prayed for that the defendant appellant number 2B has expired, and his only legal heir is his mother, who is a party to the appeal, my lord. Her name
So
is,
we'll allow this and again that will be there. Take down, yes,
my lord.
the suit for partition. The
Suit for partition, yes.
for partition that was dismissed against that.
Have you served?
The notice of appeal has been served to department, my lord.
কি রিপোর্ট আছে দেখি দাও তো।
Department, my
কি
lord.
রিপোর্ট আছে দেখি। এ তো রেক্টিফাই হয়ে গেছে।
And my lord, this is the application for stay of the operations of the order. One of the main grounds is this, that the appeal was filed
আরে রিপোর্টটা
on the
রিপোর্টটা
ground.
দেবে সাব হলো কি হলো না 3rd সেপ্টেম্বর পাঠিয়েছে। থার্ড পাঠিয়েছে। Proceeding has commenced.
No, my lord, the appeal was, the suit was dismissed. Against that, the my lord appellant, the applications has been filed. Appeal as well as the application for stay of the operations has been filed. The grounds of the appeals is this, that mainly only two grounds, that for non-joiner of parties and shares. The property
Non-joiner of parties
and shares. It is the my lord, Mohammedans properties, my lord. The all the parties are in the record.
all the parties are
In the record. Till then, my lord, the matter was dismissed on the ground of non-joiner of parties.
all the parties are on record.
Yes. And my lord, the shares of the Mohammedans, my lord, that is tenancy in common. Even the my lord, the partial partition can be made. So, my lord, the points which have been stated in the memo, that is paragraph grounds of appeal, my lord, 5 to 8, I have stated that to be admitted as well as my lord, stay the operations of the order, because otherwise I have to
No, stay, there is no scope for stay. The appeal has to be heard out.
Yes, my lord.
And there's no scope for any stay. They have to be heard.
It will be hard to get this, my lord. Wrongly I have stated it. Sense of the order, my lord, judgment and degree, my lord.
No, but there is the decree of 14 July.
Yes. 14.
And you have filed the stay petition when? You have filed the stay petition much belatedly. No, in October, but the defect was only cured on very recently.
It will be within time, my lord.
July 2023. But 20th September 2024 defect cure করবে। Cure করার পরে
Appeal both filed simultaneously, my lord. Within time.
Were you enjoying any interim order during the pendency of the suit? Were you enjoying any interim
Yes, my
order?
lord. In the court below, my lord, the status quo order was there.
Was there?
Yes.
Can you show us the order?
No, my lord, that was not here, my lord. The lower court records may be called for, my lord. Partition suit, my lord, generally, my lord, the status quo order
ওখানে একটা কাজ করো,
My lord, notice to be served to the contested parties, my lord, only. Notice service.
upon the contested
yes, madam.
upon the contested defendant. Upon the contested defendants.
Lord,
Yes.
may it please your lordship. Lord, I beg to appear, my lord, on behalf of the landlord respondent before your lordship. Lord, this is
Landlord respondent.
This is an
For the
application.
appellant defendant,
You are the appellant.
appellant defendant.
Lord, this is this is my application, my lord, for enhancement of the occupation charges, my lord, which has been granted as a condition for stay, my lord, being enjoyed, my lord, by the tenant. My lord, the amount which was fixed, my lord, this is a property at Sharad Post Road, where, my lord, he's occupying about 1,070 square feet, including a car park. My lord, that has
Lordship, I intend to use an opposition against this application.
kindly fix the appeal as well. In the meantime, let them use an opposition as well. I have no problems at all.
Now, when there is an order, when an order was
So the
November.
first order, my lord, if your lordship turns to
Page 30.
page 38. Looks to page
আমাদের order
38.
file,
38.
order file টা
Of can 2. Can 2. Page 38. Can 2, my lord, page 38.
বসাচ্ছি, order দিয়েছি।
আমার briefটা
It was only passed on 20th November.
That's right, Lord. It's on 20th November 24. Even that was, my lord, on a very, my lord, conservative way. My lord, Supreme Court initially, my lord, passed to 16,000. Then, my lord, it directed, my lord, 25,000, and that has been on basis of that it's going on. Kindly have a look at the 25,000 is
This
based
was
on a
only
Supreme
passed
Court's order.
Not even a year ago. Not
No, my
even
lord,
a year
it's based on an order which was passed long back. Kindly turns
ago.
back.
Maybe, but we are not.
Page 14 once, my lord. Page 14 once.
His submission was considered, your
Allow
lordship.
me to finish. Allow me to finish.
No, what is the Honorable Apex Court order?
Yes, my lord. Page 14.
Page
14. 1-4.
1/4 of Can 2.
Of Can 2.
No, Can 2, 1/4, that's different. Okay, just Can 2 টা কি না? Can 2. It did not pay this amount. Yes,
Kindly sees below the third paragraph.
yes.
We therefore direct the respondents to pay occupation charges from 1/5/2006 to 31st August 2016 at the rate of 14,000 per month, which is not paid, if I'm not mistaken. Same shall be paid within 8 weeks in 2 installments. Am I correct that they have not paid?
They have not paid.
First installment shall be paid within 4 weeks, which is a sum of such and such, and next installment shall be paid within 4 weeks thereafter, which is also a sum of such and such. Use and occupation charges shall be paid at 25,000 rupees. So this assessment, my lord, was based on that, and this also they have not paid.
That's a different issue.
My lord.
Compliance, okay.
Have not paid.
But enhancement is a different issue.
Enhancement is different, my lord. If they are to have equity, my lord, they have to comply. This they haven't complied with.
Yes, that's a different issue. They
Only after
have
Justice
complied or not.
Bhattacharya's order, my lord, that they paid 25,000 rupees. That's it. The areas were never paid. Huh, 33. Yes, I'll come to that. I'll come to that. Aste, aste, aste. তুমিও তাই।
No, but paragraph 9 says so.
My
In
lord?
case of default by the appellant to pay
This
any
is
of
with,
the
lord, with
installments of
respect to
arrears
the payments of 25,000.
or the current occupation charges.
My lord, it's with
Any of
respect.
the installments of arrears
Yes, my lord.
as well as the current.
Now it has been stayed.
However, the stay order passed shall stand automatically vacated. That for the paragraph 9 is there.
Areas were never paid, my lord.
So as far automatically payment.
Never paid. Areas never paid.
So you
Kindly records that, my lord. I'm happy with it.
not required. It's already there in
My lord,
paragraph.
this is with respect to the amounts which were directed by the High Court.
To pay any of the installments of arrears.
That's
or the
As if
current
the
occupation
appellant pays
charges.
the area occupation charges from the date of the impugned degree.
Yes, on the
My lord, the
degree.
Supreme Court's order, my lord, was before that.
But this order all areas 20.
Degree, my lord, is in 24 and the Supreme Court's order is 22.
Supreme Court
Yes, that order merges with the decree.
So, my lord, this was never
So,
paid.
no, whatever is there, so it's a fresh order by the
My lord,
decree.
my lord.
It's
So
a fresh
here,
order.
my lord, it's,
So in the event the appellant deposits occupation of 25,000 per month,
my lord,
the first of which for the month of November
my
2024.
lord.
So if they 2024 and this order was passed on in November itself.
24.
Yes.
Yes, my lord. But this is
And
based on,
thereafter by 10th of each Sasimha as well.
my lord, what I am trying to, my lord,
As if the appellant pays the area occupation charges on the date of the impugned decree in 5 equal monthly installments.
my lord. This was with respect to after 24.
Lord, before 24, it has taken care in paragraph 5 at page, Lord, এটা page number কত রে?
কোনটা?
এই orderটা
38.
এটা পড়া
39.
39, Lord, paragraph 5.
The
Last
same
paragraph.
number of assessed of the-
No, that's on the basis of the degree. In terms of the degree, the heavy amount, my lord, which is required to be paid by them was never paid. So equity can never be, my lord, on their favor.
Rent was 14,000 per month. Supreme Court said 25,000. My submission was kindly make it somewhere in the middle because there's no assessment at Supreme Court. Their submission, Lordship will find in paragraph 3, is that 25,000 should be the amount fixed.
And that
And
was
as per
fixed
their submission, 25,000 was fixed.
2016.
And now, Lord, now what they have done is to assess the higher rate. This valuation report that they have annexed is a complete scam. It,
Lord,
rela-
your
it,
lordship
rela-
sees,
it,
my
it
lord.
relies upon magic bricks, relies upon the 99 acres, which is the biggest scam because anybody can upload any figure on the site.
No,
There's no assessment done by
you have
valuation.
suffered a decree for eviction.
Yes.
So for a 1,000 square feet in short.
No, it is less than 1,800 and something square feet.
My lord, it's there in the plain. 950 square feet he's enjoying and 120 square feet is his car parking space. It comes to 1,100 square feet.
No, right? If your lordship has a look at page
Service quarter.
48,
But why this in 5 equal monthly
internal
installments?
page 2 of the report,
No, why it says in 5 equal monthly installments?
836.27 square feet
Mr.
and
Sen, where is the arrears come in paragraph 7? It says if the appellant pays the area occupation charges.
40.
What was the area
আচ্ছা,
occupation?
তোমাকে
When
জিজ্ঞেস
the
করছেন
decree was
40
passed. When the decree was passed.
Not 24.
No, 24.
I'm sorry, November, February 24. February 24.
So February 24, you are supposed to pay 25,000 per month.
I have been paying that.
That you have paid, the arrears you have paid. That paid.
From that period.
Yes, that's fine. That's why
There is no claim for areas before your lordship, Lord. There is no claim for that in this
It's just been
application.
recently done. We don't want to.
Lord, with respect,
Yeah, we fix the appeal. We are okay.
your lordship fixes the appeal not just after the vacation.
Let's
For the appellate.
Lordship, item number 15, Mr. Sufi Kamal, who is appearing for the respondent, I am praying for not today.
Yes. Are you being appointed by the Calcutta High Court Legal Services?
No, Lordship.
Because the secretary has, I think they have report chair. Are you representing respondent number 1 and 2?
Yes, Lordship.
Are you engaged by the legal aid?
No, Lordship.
Have you filed your Vokalatnama?
Yes, Lordship, I have already filed.
File করেছে দেখো। What is this matter?
Lordship. Lordship, the respondent number 1, Lordship, filed a suit for partition, Lordship. By the impugned judgment and decree, preliminary decree was passed challenging.
Respondents or the plaintiffs?
No, we are defendants.
Defendants.
Defendants 1, 3, and 4.
So final degree proceeding may continue.
No, but Lordship, 28th of October is fixed for passing final decree, Lordship. It has to be stayed. And Lordship, can 2 is an application for substitution within time.
Give us can 2.
Lordship,
Commissioner has filed a report.
yes, I am told, Lordship, he has done. And 28th,
Commissioner has been examined.
Lordship, that I do not know. I know, Lordship, that my instruction is that 28th of October 2025
The
is
judgment, fixed for judgment,
of drawing up final decree. Yes,
drawing
good
of the
job.
final degree.
Yes, yes. Can 2 is my application for substitution within time. Appellant number 3 died.
Appellant number 3 died.
Yes. Paragraph 2 of
Okay,
my
allow the substitution and then we hear you on Monday maybe. Or Tuesday. Sure. This is your can
2, Lordship.
2 টা দাও দেখি। can 2 টা বের করো। এসো।
But I beg to appear on behalf of the my lord, respond number 1 to 9 and 11. My lord, I am told, my lord,
which was passed, my lord, filed in a miscellaneous probate revocation case.
Injured respondent mara geche. My lord, I am told, my lord, respond number 13, 14 and 15 are dead.
But you have to give them the details.
I will, my lord, supply, my lord. I'll try to supply, my lord. Already,
Who
my
have
lord,
died?
13 died 2 years ago.
13, 14 and 15.
Yes. 13 died 2 years ago, 15 died 1 year ago.
But if you have intimation, please supply. Yes,
I will
then you
try,
have to
my
take
My
on
lord, there is a
application.
delay of 59 days.
82 days.
82 days, my lord, and the delay was caused due to the certified copy and some financial.
No, that's the but unless you bring the substitute legal heirs, then
My lord, so
again there will be a
let me
problem.
provided with
I will
that.
try, my
So we
lord.
keep
The
this
only thing
application
is that
pending. You give the in course.
I will try, my lord.
my lord, only one thing I beseech your lordship, that there was no interim order earlier, but after this, my lord, some of the are trying to sell the properties which are there. My lord, this is a revocation, probate revocation case.
No, revocation was dismissed.
Yes, my lord.
Probate granted in the year 1979. Revocation was filed, my lord, 15 years after 1994. I, my lord, leave it to
The
my lord.
reason, lordship, is kindly page 23, internal
No,
page 23.
no.
But who are you?
My lord, I am the heirs of Bonomali Das, who was one of the beneficiary according to the original probate proceeding, my lord.
There are
Bonomali Shaha,
No, no, no.
who died on
One will,
1/3
one will, will of a male Hindu, wife alive, wife appeared, and probate granted, and
No,
inadvertently,
who was a beneficiary of the under the will?
perhaps, my lord, wife, from the wife's side, because the deceased, the testator and his wife did not have any issue.
So they were issueless.
Issueless. By the time probate was filed, my lord, wife alive, wife
No, but under the will, who was a beneficiary?
wife,
Wife.
because by that time
No, wife.
wife was alive. After
But
the, but inadvertently,
irrespective of the fact that if the husband died, wife would have succeeded.
yes,
As a natural heir.
yes. By that time, my lord, inadvertently, by that time, my lord, when probate proceeding was filed, inadvertently, one of the sibling was served citation. One of the sibling of the testator was, by that time, he was not, my lord, supposed to be an heir, because so long the wife is survived, my lord, class 2 will not come, my lord.
No, not that. You see that if he died, even if without leaving a will, then the wife would be the success. Yes.
Wife, no, in no way brother is coming.
No.
In no way brother is
I
coming.
guess it is
And
false.
they are saying, my lord, they are the heirs of the brothers, of that brother who have been wrongly cited.
My lord,
And
So he was, no, the gentleman was survived by wife and he has also other brothers.
yes,
other brothers. But so long the wife is survived, my lord, class 2 will not come. Class 2 will not come. Section 8, class 2 will not come.
no, if your lordship
And
takes,
probate granted 79, my lord, revocation
but
without any explanation.
But in any event, as he rightly said, that even if there is no will, the wife would have the natural succession.
my lord, as well as property devolved, lordship kindly come to internal page 2 once of the judgment, and this will give a clear picture, my lord. Kindly come to that an application for grant of probate registered as the probate case number 93 of 71. In the said case, Rajeshwari and Bonomali Shaha were arrayed as respondents. They were the near relatives of the deceased testator. In the said proceeding, written objection was filed and it was returned for the filing as contested proceeding before the learned district judge Murshidabad. Thereafter, Nilmoni Das, the executor, again filed the same before the learned district judge Murshidabad. It was number.
Nilmoni Das was the executor.
Executor.
Yes.
Now, Nilmoni Das was the executor, and Nilmoni Das lordship happens to be the person who filed this case in the original probate suit in 1972. Initially, the probate case in 71, thereafter contested before the district judge in 72. My lord, what happened is Nilmoni Das filed it. In that proceeding, this Rajeshwari was a party, as well as this Bonomali was one of the party. And now in this case,
Who was the beneficiary?
now in that particular will,
What is
my
the
lord,
name of the beneficiary?
Many beneficiaries. I
Succession
do
Act.
not have the will even.
Into Succession Act.
উল্টা
ওর মধ্যে আছে, ওর মধ্যে যেটা নিয়ে ঘুরে বেড়াচ্ছে ওর মধ্যেই আছে।
হিন্দু লটা দিন না, তার মধ্যে পাওয়া যাবে।
Yes.
my lord, kindly come here. That in 1976, Nilmoni Shah illegally and fraudulently caused the filing of Vakalatnama of Monomali Shah. This was the contention. In said probate proceeding on 29/9/1978, and thereafter Nilmoni Das obtained an ex parte order. So order was
No,
obtained
so when the will was probated, by that time the wife also died.
died. That is recorded
Wife died in 1970.
on 12/12/1977.
Then it will fall back upon the
Devolution.
Right, my lord, during the lifetime, my lord, perhaps, my lord, the entire record, may I tell, my lord,
there was,
yes,
once the wife died, then it is open succession.
Yes.
You come, the male heir should come.
yes, yes, but the wife did not,
Then
perhaps, my lord, the
And
wife,
then this will is redundant. Will is redundant.
my lord, I cannot.
Will is redundant because after the death of the wife who could be the beneficiary, and unless she makes another will, it will follow the succession.
Succession, and that should have been correct.
So it tells the probate proceeding itself is become infructuous. Nothing remains.
No, probate proceeding was of the husband of the, my lord.
Husband has given to the wife.
No.
Husband has given to whom?
Many persons, I do not have the copy, because it is a old file, my lord. The file, entire file was destroyed, and pursuant to the an order of the,
Wife is not the only beneficiary.
perhaps, my lord.
Just now you said wife is the beneficiary only.
No. Wife was the life interest. I understand, my lord. I cannot. I'm trying to find out, my lord, the copy of the will, whether it is
My lord,
available.
if your lordship come to the respondent's case, lordship in the next page, that is internal page 3. On 5/9/2002, the respondent's file.
Means firstly upon the yes.
My lord was, my lord, destroyed. So, my lord, nobody knows what happened to that particular proceeding. On the basis of some certain available documents by the order of this honorable court, this proceeding was, my lord, initiated.
So copy of the will is annexed, copy of the will.
Lordship, the original probate proceedings papers are missing, and that has been destroyed.
I'm
That is
trying to,
recorded
my
in the
lord.
order.
The probate is there.
If your lordship kindly come to internal page 23.
এখানে আটকে যাবে son daughter widow এখানে কেউ
From this expert he was running.
exactly
ওখানে ম্যাটারটা এন্ড
না জিনিস is under the will.
My lord, my case is, lordship kindly come to.
No, we just want to see the will. Where is the will?
My lord, this has been destroyed as per the law. Kindly come to page
when was the
20.
probate granted? Probate granted?
79.
Probate 79. The probate was granted.
And it was revoked when?
Revocation filed in 1994.
94.
So probate granted 79.
79. 15 years
During
after.
the time of the grant of probate, this Bonomali Shah, the case is.
So why this
Bonomali
type of,
Shah's
why this interference after so long period?
Nothing
Unless
has
there is
been
a
in their
special cause.
application. And
Kalatnama,
where from, my lord?
Bonomali
that has been taken
not to
care.
be executed
Yes,
on that day. Lordship, if you lordship kindly come to page 23, internal page 23. Lordship, may I be permitted to read from this?
Yes.
There is neither any allegation nor any proof that grant of probate was defective in substance or fraudulently obtained by untrue allegation or by any concealment. The only other ground, apart from the filing of the forged Vakalatnama.
So you are the appellant.
I'm the appellant.
Appellant, you are
Who
challenging
is
the revocation.
Rajeshwari and who is Bonomali?
Rajeshwari is the wife of the original testator. That Advaito Shaha did the will in 1950.
No,
Now,
so Rajeshwari was the
wife of Advaito
so
Shaha.
Rajeshwari is also the beneficiary.
Well, if she should be the she was
Under
made
the will, she is a beneficiary.
that will is
I'm
not.
trying to, my lord, read it, my lord.
But you file a revocation
No.
without, and who is Bonomali?
Bonomali is brother of Advaita Shah.
No, you
Brother.
filed a revocation. That revocation was dismissed.
I filed the revocation
Yes.
and revocation application has been dismissed again, which I have.
What is the so
সবাই মারা
revocation?
গেছে, বনমালীও মারা গেছে,
Take this the only other ground apart from the filing of the forged Vokalatnama taken by the petitioners, the case which finds place in illustration 2 of section 263 of the Act is lack of citation on the parties who ought to have been cited. But in the instant case, the petitioners have themselves admitted their predecessor in interest, Bonomali Shah, and the wife of Rajeshwari Shah, were made parties to the probate proceeding filed before the district delegate, and thus citation is evidently established. Since objections were also raised and the proceeding had become contentious and was subsequently registered as testamentary suit number 3 of 1972, probate case number 49 of 1972. So this ground too appears to have no validity in the instant.
I have a
Perusal of the photocopy of the impugned order granting probate dated 8/8/1979 as found in the case record, since no certified copy was filed with the instant revocation application, and subsequently it was informed to this court that the case record testamentary suit number 3 of 1972 was destroyed after 25 years in accordance with law during the pendency of the proceeding, reveals that on the day the opposite party, Rajeshwari Shah, dead and Bonomali Shah, was found absent on call, and the suit was taken up for ex parte hearing, and Nilmoni Dash, executor, was examined as PW1, and deposition of PW Jamini Kanto Ghosh, examined on commission, was tendered and read as evidence, and the will was marked as Exhibit 1. And considering the evidence, the learned court came to the finding that will was duly executed by the testator.
So it was a contentious.
Contentious. And it was legal and the valid document, and accordingly probate was granted. Further perusal of the photocopy of the will of Advaita Charan Shah reveals that it was a registered will and was presented for registration on 11th August 1950 at 2 p.m. at Domkol Azimganj Sub-Registry Office by the testator Advaita Charan Shah and Kishori Mohan Bishwas. Satkori Hor, Horipodo Shah, and Jaminikanto Ghosh were the attesting witnesses. Since the learned probate court had taken into consideration the evidence of one of the attesting witnesses to the will, it is evident that the will was proved in accordance with the provisions of section 868 of the Evidence Act, and the conscience of the court was duly satisfied. So I put this question now, while making this finding, there was no access to the original file of the probate proceeding. So there was an allegation that there was fraud by filing the Vakalatnama of Bonomali Shah on 21/9/1978, even though he had already died on 1/3/1976. A person who died in 1976, the
Vakalatnama has not been produced ever by them or the court. It is mere allegation that is not recorded anywhere. That Vakalatnama cannot be found.
That has been destroyed during the pendency. It is also recorded.
It is their contents and it is their allegation. And here is the copy of the will, my lord. May I hand over, my lord? It is little bit marked.
See, point number 5 is
recorded. Where from they came to know this? There was no Vokalatnama.
Page 7, paragraph H also includes that there is a public documents which are the death certificate of Bonomali Shah and Rajeshwari Shah, which was there.
অ্যাপ্লিকেশনটা কোথায়? এটা তো দিসনি কোথাও। রিভোকেশন অ্যাপ্লিকেশন।
Point number 2 will give some picture, Lordship, on this. The question your Lordship has asked initially, that in absence of if the wife dies, then what will happen? That has been dealt.
You are the legal heirs of Bonomali?
Bonomali. It is not confirmed.
Bonomali still have the right to contest. Bonomali মারা গেল, granted, it does not affect your right.
Well, the problem is what is happening, Lordship, that in some of the properties we are in possession. In some of the properties there
Consequence upon the grant of probate by reason of the death of your maybe Jetima or Kakima, whoever is there. It will come back to you following the succession
that
act.
should have that
So as long as there is no revocation, was completely a misconceived application. It is completely a misconceived application
if
having
it is,
regard to
then
the
it
death.
will have no effect.
So why you are contest? Why we are trying on something which has.
My lord, since it is an order of the court, unless it
No,
goes
revocation can be passed on the grounds what is provided under the statute.
Revocation is
beyond that.
Today the revocation is meaningless. Having regard to the fact that the beneficiary died, and we are not aware of if there are any other beneficiaries.
No. But the wife was not the, my lord, have a look to the will.
Where is the will?
Yes, my lord, I have a, my lord, it is marked, my lord.
So where is the original will? Original will cannot be destroyed.
That may be with the custody of the court.
So original will has to be seen. Original will always original will.
Executed 1970.
Will executed
Yes.
1950. My lord.
Lordship, will was made in 1950.
1950.
Lordship, the original testator, he died in 1955.
स्त्रीय लाइन के लिए
Will.
Yes.
And drafted by advocate or in his own handwriting.
Now, where is have you exhibited the original will?
My lord.
Have you must be the original will?
My lord, perhaps that has also been destroyed. So far, the report
original
of the
will cannot be destroyed.
That is the difficulty. Because my lord will find an original. May I hand over, my
The
lord?
record may be destroyed, but how the original bill has to be returned to the, but it has to go back to the executor.
Should have been.
Revoke তো হবে না।
Original?
Once the grant of probate is there, it should be with the executor.
No, no. It remains with the custody of the court.
If there is no appeal preferred,
It remains with the only copy of the will is supplied, my lord. My lord knows very well in our original side rules, my lord, original side, my lord, on 50,000 court fee which we pay, on that, my lord, grant with a copy, handwritten copy of the will.
correct, we
Yes.
preserve it, but if you ask for it original,
No.
sometimes you issue the certified copy of it.
Certified copy, yes.
But if anyone is required for inspection, then it is
He
produced
can
for
inspection as per the, my lord, civil procedure and rules, my lord, there.
But it থাকবে তো এখানে। You ask. He has filed an application on the basis of which it was marked as a contentious cause. Then up to 94, the heirs of Bonomani did not get themselves substituted.
But what has that?
So in the meantime, if the administration of the SCL is over, then we cannot undo it today.
No, the
My
only
lord,
thing
may
is
I
that
tell,
only
my lord,
when-
the other things are there. Why in 1994 they, my lord, filed this revocation? Because the previous, their, my lord, predecessors' names were appearing in the record. By showing the
On
record,
the basis of the probate, grant of probate,
yes,
the mutation, everything was done.
yes, yes. They have, my lord, they have sold the property by appointing a, my lord, a power of attorney in 1994. Thereafter,
After that dispute arose.
After that dispute arose, they come up. They have suppressed everything.
Why?
They, because, my lord, they do not stay there.
No, but this point is taken before the trial court. This says,
My lord, separate civil suit has been filed, 2 suits.
no, in
The-
this,
in
this
the
application for revocation, have
No,
you
my
stated all these
nothing.
things before trial court?
After that, my lord, 2 separate civil suits were filed against the persons, and both the suits have been degreed.
If your lordship kindly come
Both
to
the suits
point
have
number
been
2.
degreed. They only say we filed a revocation, but thereafter they did not turn up to the suit, and both the suits have been degreed in our favor.
My lord, the first
The original, my lord, copy of the will, my lord, that has been, my lord, I have handed over the certified copy.
it was an ex parte order. My lord, in my reading shows that if the Vakalatnama,
No,
which
you have
this
to
is-
show that your father during his lifetime, what kind of objection it was led, and whether the probate proceeding was, if it is ex parte, and your father, when the probate was granted.
79.
Very, very well. But by that time, his father died.
Yes.
So if his father died, then there has to be the legal heirs of the father has to be substituted.
Because wife was not contesting. Wife was not the wife.
If the brother has been cited.
Because wife was alive by that time when probate proceedings was filed.
Because maybe, but apart from the wife, it has given to some other person.
No.
Yeah.
So long the wife
If it
is survived.
So long, very well. But only
If
after
the wife did not choose to contest, then
it becomes a contentious cause.
on Bonomali's, my lord, filing of.
Please allow us.
Yes.
Bonomali filed an affidavit.
Yes.
That was on the basis of which it was marked as a contentious cause.
But he was by, yes, sir.
It was marked as a contentious cause.
Yes.
Now, if when the probate was granted at that point of time, the property gives to various other persons to the wife's line, they would have been the beneficiary. So he was contesting that. Possibly his case was that whatever we do not know, Bonomali has said in the affidavit. He said that this disposition of property in favor of the relations of the wife was wrong.
Maybe, I do not know.
No,
We do
must
not
be.
know.
You are the executor. You are the executor.
Perhaps my father's father, my lord, was the executor. I do not know.
No, but the record will speak for itself.
Record is not available. That is the
original
difficulty.
will must be there.
It was past expert. Because by that time the probate was granted.
My lord,
because Bonomali died on 1st March 2076.
Yes. And Rajeshwari also died.
Rajeshwari died, my lord.
1979.
And how, if the Bonomali died, how a Vokalatnama can be filed on 21?
It is their allegation. There is no record, and they did not, my lord, they did not substantiate this contention. It is their mere allegation.
But was there any Vokalatnama filed on behalf of Bonomali? Of course, it must have been filed.
Yes.
Otherwise,
It must be filed in 1972.
yes, 76.
Maybe.
Yes. No.
Lordship takes point number 2, which you will get. Because Advaita Shaha, the administrator, he died issueless, leaving behind his wife Rajeshwari Shaha on 14/3/1955, and admittedly, there were no other legal heir apart from the wife. Under Hindu Succession Act 1956, Rajeshwari was served with the notice of the probate proceeding, and so Bonomali Shaha, the brother of the testator, who was also served with the notice, and objection was filed, which proves the service of this special citation. It is the law in the properties of Advaita Shah during the lifetime of wife Rajeshwari Shah. Neither Bonomali Shah nor his legal heirs were statutory heirs of Advaita Shah, and they had no locus standi to seek revocation of probate. But after the demise of Rajeshwari Shah, only in the event that Advaita Shah had died intestate, the property would have reverted back to his brother or his legal heirs. But in the instant case, the petitioners have not alleged that Advaita Shah did not execute any will, that it was forged document, or that is it was executed under fraud, coercion, and undue influence. Moreover, Bonomali Shah had already been impleaded as a party to the probate proceeding and had contested the probate proceeding in his legal heirs, ostensibly had the knowledge to probate proceeding. As the instant proceeding, they had prayed for revocation of the probate entirely on the ground of the forged Vokalatnama was filed in the probate proceeding on 21/9/1978. In the meantime, Bonomali Shah, while he had died on 1/3/1976, moreover, perusal of the photocopy of the other order dated 8/8/1979, granting probate, reveals that it was passed ex parte evidently. So that is the only bone of contention, my lord, that the Vakalatnama was.
That was not found. That is mere allegation.
And it is also destroyed.
How could they know that on a particular date? That point has been raised by the court. When, how, my lord? Kindly see their application. Where from they got the knowledge? Yes. Not come in anyway, because after Bonomali, my lord, Rajeshwari Saha died, wife died. Bonomali previously died. That is
not the point. Point is this, that disposition is bad. Because if this, first of all, whether this one question is whether Bonomali has any caveatable interest or not.
It was not there.
No. Was he required to be cited? So whether he could have naturally succeeded to the estate on the death. So in presence of the wife, he is not required to be cited.
Yes, that was wrongly done. That was wrongly done. And Bonomali, my lord, Bonomali died
You are not required to be
76.
cited at all.
Yes, wrongly done.
You are not required to be cited, and by this citation, you
Wrongly
cannot
done.
acquire any right.
So
He has no caveatable interest.
Take down.
I was made a party.
was saying, my lord, this certificate, previous matter, my lord was saying that will to be kept in the safe custody, but it is kept. But the difficulty in the trial court, the district court is there. My lord, they do not usually, my lord, supply the certified copy of the will to any other person. That is the difficulty. My lord knows very well. Grateful.
Land acquisition proceedings, my lord. A delay of 158 days, my lord. There are two applications, my lord.
You have not put up the notice of appeal. You are appearing.
Yes, my lord.
For
Caveator, my lord. The original claimant, my lord. Respondent claimant.
appeal the card.
Appeal made by the state.
You are for the respondent.
Yes, my lord.
You are for the state.
My lord.
Very well. So the usual order, how many days delay?
158 days delay, my lord.
Very well. 158 days delay.
It is during the COVID period, my lord.
Very well. না দেখে আমি আগে রিপোর্টটা দিই
Condonation.
হ্যাঁ ওটা তো না ওটা that will expedite the thing. আরে রিপোর্টটা কোথায় দিয়েছে বাবা স্ট্যাম্প রিপোর্ট The appeal is in time in view of the judgment of the Honorable Supreme Court, in view of the order of the Honorable Supreme Court, dated 10/1/2022 in SMW bracket C, number 3 of 2020. The application of condemnation bill is thus disposed of. Next, the usual order for how much you deposit the compensation amount.
My lord. They have levied a money execution case, my lord. Execution case number 11 of 2021.
এটা আমাদের এলেতে অর্ডার হয় তুমি জানো তো ফর্মেটটা দেখে নেবে সঞ্জীব
the instruction to appear for the respondents, my lord, but I have, my lord, yet not received the wakalatnama. If your lordship kindly take.
Stop and come back on Monday.
Yes, my lord. If it can be taken up subject to your lordship convenience on Wednesday, my lord.
Wednesday.
Subject to your lordship convenience.
Well, they show on the prayer.
Home over phone. He's a very sick man.
When we should keep it?
Not today only.
Not today. Very well.
Number 20.
Lordship, I am appearing for the appellant. Affidavit of service has been affected, Your Lordship, as per direction. Your Lordship, praying for accommodation after puja, my lord, as the learned counsel for the matter is not
I am for the respondent
able to appear
opposite
today.
party.
You are appearing
I am for the respondent opposite party.
after vacation?
Yes, my lord.
Very well.
Five, my lord, in preferring appeal, originally there was a delay of 16 days, but from the report of the SR, it finds that deficit court fee was there. I put the court fee later on, that's why further delay occurred. I have stated in the paragraph 7, 8, 9.
Condone the delay.
আপনি আছেন? The eviction suit.
On the ground of default?
No, my lord. Earlier suit was filed for eviction that was subsequently withdrawn by the, my lord, respondent. Thereafter filed the present suit for eviction as a, my lord, trespasser. I am, my lord, running the business as a partner of the, my lord, Ganesh stores. My lord, the 2G of the definition of the act is, my lord, I have been authorized to run the business. That was not considered, my lord, at all. This is a partnership business. Being a partner, original partner, my lord, died. Thereafter, my lord, my lord, being a remaining partner, my lord, running the business and got the license from the authority.
Yes, yes.
My lord, I am appearing for the respondent. First, my lord, coming to the delay. Learned senior for the appellant.
We have condoned the delay. We have condoned the delay.
Yes, my lord. So, I want to file opposition with regard to the stay application. Let the matter be fixed after puja so that I can file my affidavit in opposition with
Execution case has started.
Yes, my lord.
Yes, my lord. It has filed. It has been filed.
Time being
But
filed, kindly stay the
consider-
execution. Let them file opposition. I have no objection.
My lord, we need to file the opposition.
No, what are the grounds for eviction?
My lord, the ground is that he is a trespasser and he is a defaulter. Let me just place on record that
Trespasser, defaulter cannot be clubbed together.
That, my lord, this is the suit property is a one shop room of 200 square feet on Rashbiari Avenue. Now he was in the original tenant was inducted at 70 rupees. Now for such a long time, since 1980, now this trespasser has come into place. They are in occupation. They are not paying any occupational charges on and or any type of rent.
No, the tenancy was given to someone else.
No, Ganesh Stores is a partnership firm.
It was given to Ganesh Stores. Now he has
So
come as a
Ganesh Stores
trespasser.
is not carrying on the business.
Yes, my lord, I am being the partner.
Yes. What is your case?
টু জিটা বের করো definition 2G last paragraph দেখো 2G definition 2G
What was the rent?
My lord, the initially rent was rupees 70.
How much?
Rupees 70. Way back in 1980.
Rupees
70.
70.
70, my.
At what time?
1980, my lord. Now, my lord, we've claimed mean profit of 2 lakhs and the rental value at the time of filing this suit was 15,000, which appears from the impugned judgment.
Market rent is 25,000.
And the market rent is 25,000.
So rent paid by the deceased was how much?
It was
Deceased tenant?
70 initially. Thereafter,
Thereafter, lastly, the deceased paid rent how much?
What was the
originally
ground
it
for?
used to be
What is the
70.
ground for eviction?
Eviction case. Grounds for eviction case.
My lord, the ground is that he's a this person is a trespasser who's come into possession of the property and of the shop room, and the second is that he's a defaulter. Those are the two grounds on which the entire case
No,
is.
trespasser cannot be a defaulter.
Yes.
You see, if he is a rank trespasser, he
He's a
cannot be a
rank
defaulter. So is it 2G means after the death of the original tenant, 5 years have passed? Is it your case?
Yes, that is my case.
Partnership form বলছে তো।
বের করেছো
Rightfully pointed out in page 22 of the impugned
So
judgment.
rent was issued in which name? This is this partnership firm's name or this person's name?
Initially, my lord, it was named in Ganesh Stores. The tenancy agreement was with Ganesh
তারপরে ও
Stores.
যখন এসছে জিজ্ঞেস করছে ওর নামে আছে নাকি টোটাল
Any document exhibited that it was a partnership firm
they could not prove it.
before the trial court?
Yes, my lord.
Any document exhibited?
My lord, this is the partnership deed.
No, before the trial court that there was a partnership deed. You are the
Yes,
partnership
that
firm.
was my lord filed.
And total number
My
of
name have been my name have been managed here. Ajit Kumar Das as a partner. I have been inducted 1993.
So then the question of default comes.
But he filed the suit, my lord, eviction and default ground. That cannot be clapped together. As per Act, my lord, I have been authorized by the partnership firm to my lord, run the business. The definition of the my lord 2G.
How many
Support me.
partners? How many partners were there total?
Initially 2, thereafter inducted more 3 partners, and 2 partner my lord died. Only I was there. The corporation also issued the my lord trade license.
Okay, in the name of this
Name of the Ganesh Stores. Now my lord Ajit Kumar Das is the pup.
You are the predecessor of the original tenant. You are a predecessor of the original tenant.
Yes, my
So how could be a predecessor of an original tenant?
original tenant was Ganesh Stores. There is a partnership between Nepal Chandra and other two brother.
Who was the tenant?
Ganesh Stores.
Honest stores. You failed to produce the rent receipts.
Everything, my lord.
Rent all rent receipts not come and defendant is, you have not, that is a finding. There is a finding that all the rent receipts were not produced.
But I have been treated as a trespasser. How mal can be?
The suit was not filed under section 6.
Yes.
It was not filed.
Not.
On the ground of
Trespasser.
you being a trespasser.
Trespasser and defaulter.
No, whether you trespasser or defaulter, if you are also held to be a defaulter, even if you held to be a tenant, so your defense was struck off as a tenant.
You see, unless it is filed under section 6, how this 7.1 comes into play? The 7.1 and 7.2.
That is the
question is, you have not, that means you have accepted yourself as a tenant. That means the moment this 7.1 and 7.2 comes, you are accepted as a tenant. Now, whether you have defaulted or not.
That should be decided.
No, but when this suit was filed, they claim you trespasser on the expiry of the notice period. But then you have to file an application under 7.1 and 7.2. Relationship of landlord was there, but by reason of whatever the reason, so you were required to file an application, and if they are not receiving the rent, then there is a procedure, either court deposit.
7.1.7.2.
7.1.7. Have you done 7.1.7 to file an application?
I need to. That was not, my lord.
You have not filed. Then your defense is liable to be struck out. Your defense is liable to be, as a Supreme Court judgment. Your defense is liable to be struck out. Yes.
But written
you should have filed an application under 7.1.7.2.
7.1.7.2 file হয়েছিল কি? My lord, I have stated in the written statement that I am a tenant, not trespasser.
Question is whether there was any application under section 7.3 striking out the defense.
7.1.7.2.
My lord, this has been explained in page number 17 and page number 18 of the impugned judgment.
What he is saying is this, that you have not filed a suit for eviction on any of the grounds referred to in section 6. If you have not done so, then there is no obligation for him to file 7.1. The 7.1 would come provided you file a suit for eviction on any of the grounds mentioned in section 6. Namely defaulter. He may be, as a consequence of defaulter, may be a trespasser after the period. So have you said that have you taken the ground in the plaint as a defaulter?
My lord, my simple case in the plaint was under 2G. Thereafter,
to disclose the plaint, will consider it. In the meantime, you grant.
Yes, my lord.
What was the last rent you are paying? Have you deposited the rents with the rent controller or court deposit?
Rent controller. Rent controller.
Since when? How much amount you have deposited?
This challan was there, 70 rupees.
How much?
70 rupees.
From 1970?
Yes.
From 1980?
1980.
Deposited in the name of the deceased person.
Ganesh Stores.
No, Ganesh Stores, yes, that fund.
Deposit 10,000 rupees, then we shall sit with. Take them. বলে দিলাম তো 10th বলে দিয়েছি তো দেখোনি তুমি
হ্যাঁ,
দেখো হ্যাঁ বলে
10th November.
হ্যাঁ This is an application for substitution